Be ready for the dictation. 5 seconds to go. The petitioner is a manufacturer and supplier of corrugated boxes, cartoons, rolls, and other packaging materials. It is stated in the petition that it made certain supplies to the respondent on the terms and conditions mentioned in its invoices, but the respondent has failed to make payment against the invoices in full. By a legal notice dated 6/11/2023, the petitioner called upon the respondent to pay the balance sum of rupees 1 crore 25 lakh 80,425 due on 15/9/2023 and invoked the arbitration clause contained in invoices. The authenticity of the order can be re-verified from Delhi High Court order. The petitioner proposed the name of an arbitrator. Learned counsel for the respondent replied to the notice on 5/12/2023 inter alia contesting the existence of an arbitration agreement. The petitioner has therefore approached this court for appointment of an arbitrator. Notice was issued in this petition on 8/1/2024, pursuant to which the respondent entered appearance through counsel on 14/3/2024 and sought time to file a reply. Time was also granted to the parties to file written submissions on the question of whether an arbitration clause in an invoice can constitute an arbitration agreement under Section 7 of the Act. The respondent, however, remained unrepresented on the next date of hearing, that is 7/5/2024, and it was directed court notice be issued to the respondent. It was made clear that if the respondent does not appear despite notice, the petition will be taken up for hearing in its absence. The registry reports that court notice has been served upon the respondent at one of the addresses mentioned in the memo of parties and also through email. At the request of the court, Mr. Ayush Malhotra, learned counsel for the petitioner, has also telephoned learned counsel who appeared on behalf of the respondent on 14/3/2024 at the telephone number available in the communication dated 5/12/2023. The matter was passed over to enable him to appear, but he has not appeared even on the second call. The respondent thus remains unrepresented today, although the letter dated 5/12/2023 was addressed to learned counsel for the petitioner by the same learned counsel who had appeared on behalf of the respondent on 14/3/2024. The respondent has neither filed a reply to the petition, for which it had been given two opportunities, nor filed written submissions in terms of the order dated 14/3/2024. Although a stand is taken in the reply dated 5/12/2023 that the respondent's signature was only in acknowledgement of receipt of the goods and not in agreement with the terms and conditions, that is not a matter which can be decided in these summary proceedings. As stated above, the respondent has also not filed an affidavit to deny the case pleaded by the petitioner despite being given opportunities for the same. In these circumstances, keeping in mind the limited jurisdiction of the court at the pre-reference stage, I am of the view that the petitioner has made out a case for reference to arbitration, leaving all questions open for adjudication by the learned arbitrator, including the defense, if any, with regard to the existing of the arbitration agreement. Dr. L.P. Mishra submits that the said report was prepared without the participation of the petitioner and without giving any opportunity to give a reply to the allegations that now form the basis of the passing of the impugned order.